Good morning, everybody, and welcome to the Collyer Bristow Digital Asset Law and Regulation Update. And I just stress the word law as well as regulation in the title because we're going to be talking about quite a lot of law and also some regulation. So my name is Nigel Brahams and I am a partner at Collyer Bristow, and I'm head of our financial services or non-contentious financial services and FinTech practice. And I've got a particular interest in blockchain and crypto. In fact, it goes way back to 2015 when I could have bought some Bitcoin for $200, but somehow failed to do so, and then therefore not a Bitcoin millionaire, unfortunately. I'm still doing this job. So looking back even just a few years, it's just incredible the popularity of crypto now, even compared to just a few years ago. So looking at some figures just yesterday, I saw that in 2018, it was estimated about 1.5 million people owned Bitcoin in the UK. And by this time last year, that had risen to 9.8 million, so it increased sixfold just in 3 years. It's incredible. And I expect the figures even higher now. And I'm still not one of them. I'm still waiting for the right moment. So today, with this huge increase in interest in all things crypto and digital asset, there's also been a big increase in terms of regulation and the interest from the regulators and from lawmakers. And with that in mind, we're particularly delighted today to introduce our two special guests. And we are joined today by Professor Sarah Green. And Professor Green was appointed as a Law Commissioner for Common and Commercial Law this year, first January 2020, actually. And prior to that, she was a Professor of Private Law at the University of Bristol, which was where I was at. And before then, she was at the University of Oxford, and prior to that at the University of Birmingham. And Professor Green has written about virtual currencies, blockchain, intermediated securities, and smart contracts, as well as sales of goods as they apply to digital assets. Sarah is joined by Matthew Kimber. Matthew Kimber is also a lawyer at the Law Commission of England and Wales, and he specialises in commercial and common law. And in particular, he is the lead lawyer on the Digital Assets Law Reform Project. And prior to this, Matt, I think, was a senior associate at Allen & Overy, where he specialised in restructuring and insolvency. And lastly, but not least, joined by my esteemed colleague, Simon de Broise. Simon is a senior associate in our financial disputes practice, and Simon has an interest in all things digital, and also in particular in litigation around all things digital. And as sure as night follows day, as soon as you have a new product, somebody will want to litigate over it. So, without further ado, the format of this webinar today is going to be, once I've finished rabbiting on, I'm going to hand over to Simon, who's going to give us a 3-minute update on some of the legal statements and policy statements from the FCA that have happened over the last few years. And after that, we're going to be moving into a discussion, and we're going to cover 4 principal areas, which will be, number one, what is a digital asset? And we're going to be talking about some themes around that. Number 2, around possession and transferability of digital assets. Thirdly, around regulation, and in particular, how some of the changes in law could affect the interpretation of regulation. And fourthly, around smart contracts. So in order to make this as interactive as possible, we're going to welcome questions from people in the Q&A button throughout the webinar. And we'll try and deal with each set of questions after we've done each theme of our 4 main themes, which will, when we do our kind of fireside chat thing. So without further ado, I'm going to hand over to Simon, who's now going to give us a quick resume on some of the papers that have been published by the authorities recently.
Thank you, Nigel, and good morning, everyone. Good morning, Sarah, Matt, to you. I'll start off just with a very brief history of the main legal and regulatory papers that have been issued by the various bodies over the course of the last 3 or 4 years. And there are 5 main ones. On the legal side of things, I'll start there. It's best to start probably with the legal statement, which was issued by the UK Jurisdiction Task Force on the status of crypto assets and smart contracts. That was issued in November 2019. It was a fairly comprehensive analysis of the then current law, and it considered how the law interacting with digital assets and smart contracts. I say then current because there have been a number of cases before the English courts that have provided a bit more insight on exactly how the law can be adapted to accommodate digital assets. And so there has been some development since that statement came out. But the statement was very well received generally, not just in the UK, but in various jurisdictions around the world. And I think it's right to say that that's formed the sort of starting point for the work that Sarah and Matt have been doing in the Law Commission. And then turning to the Law Commission's work in this area, they've been running two separate projects that we'll discuss today. Firstly was the consultation on legal smart contracts, and the advice to the government was delivered as a result of that consultation in November 2021. The second was the ongoing consultation on digital assets, and they published an interim update paper also in November 2021, and we'll be discussing these in a bit more detail this morning. On the regulatory side of things, the best starting point is probably the FCA's policy statement, PS 1922, which was issued in July 2019, and that gave guidance on the types of digital asset which would fall within the UK's regulatory perimeter. And then about 3 weeks ago, we had an announcement from the Treasury that following its consultation in 2020, the government will be seeking to implement measures to bring a wider range of crypto assets within the regulatory perimeter by amending the financial promotions order. And this was followed up more or less immediately by the announcement that the FCA has got a consultation on the rules that they're proposing to implement these changes. I think Nigel's going to be hopefully unpacking some of that a little bit later on. So Nigel, if I just hand back to you now, if that's okay.
Absolutely. So now we're going to move on to the, I guess, discussion element of our event today. So the first question we wanted to ask to Professor Sarah and Matt is about what is a digital asset. I think Simon, you're going to ask. Are you going to ask this one?
Yes, I think that's me. Yeah, I'll kick off. So yes, the first question, what is a digital asset? Not an easy question to answer. Sarah, Matt, in your interim paper, you've listed sort of 7 types of digital asset, including databases, digital files, digital records, domain names, and crypto assets. And you've indicated that there are various subcategories of crypto asset. Could you tell us your thoughts on the various characteristics of these subcategories? I guess with particular attention to crypto assets and NFTs that we're interested in today.
Yeah, do you want me to take that one, Sarah, or do you want to go?
Yeah, sure, you go. Yeah, I'll chip in. I might chip in.
Yeah, so I think the starting point for our paper was clearly our paper talks about digital assets, which is an extremely broad term, and we're also considering the context of digital assets from a principled kind of private property basis, or at least private law basis. So what we wanted to do was to build on the work that the UKJT had done, but in the broad sense of digital assets, and take principles from existing private property law and apply them to those categories of digital assets. So you'll have seen in our call for evidence that we use the term digital asset, and clearly many people kind of observe that that's an extremely wide term, which includes everything from photos to your notes app on your phone, to Bitcoin, to Word files, to kind of domain names. So we needed to split that up further. And we think that there are, I mean, our list of 7 types of digital assets, I think, was databases, digital files, domain names, crypto assets. There must have been some more in there because I said 7. But we wanted to be able to test our principles of private property law against those type of assets. And the principles that we are considering are those that already apply to existing categories of property, such as things in possession and things in action, so things that are already capable of being property. So we're taking kind of a principles up approach to apply those principles against digital assets. And I think the real thing that we're considering, one of the real things that we're considering, is whether or not a digital asset has the qualities of rivalrousness and excludability that other types of personal property have. So for example, if you apply that against things like digital files or photos that are copyable, they don't exhibit the kind of the rivalrousness and excludability that you do get from a digital asset such as a crypto asset, which you can attain those elements of rivalrousness and excludability by the locking scripts that you would apply to a UTXO, for example, or via the kind of the public-private key cryptography that is used to secure digital assets against a person's particular address. So that's the kind of the principles that we've been taking. And then I think within that crypto asset kind of taxonomy, we recognize the approaches that definitely regulators have taken in kind of taking a taxonomy based approach with utility tokens, stable coins, security tokens, etc., cryptocurrencies. We've focused more on the categorization or kind of describing what a crypto asset or a crypto token is itself as like a functional data object that can be the objects of property rights. And then we consider whether legal rights, external legal rights can be linked to those functional data objects. So that's the way in which we've approached it. And that gets you to a similar place to the taxonomy-based approach, but it's just a backwards kind of principled up approach rather than a taxonomy down approach.
Yeah, and I was just gonna jump in there and say one of the things that we've found when we've spoken to the stakeholders that we've spoken to so far in our consultation on this, one of the things that I found really interesting is how digital assets, which as Matt said and Simon said, is obviously it's a hugely broad category, and I mean it really is. But one of the things that surprises me is how often digital assets are referred to as one homogeneous whole, you know, as if they are all the same and they exhibit the same characteristics and they should therefore, you know, invite the same legal and commercial treatment in a way that, you know, we don't do that with tangible things and class them in quite the same way. So I'm not quite sure what the reason for that is, but that's certainly what we've encountered so far. And I think one of the really important things is to ensure that they are treated in their own right, you know, that those subcategories, that we really pay attention to those subcategories and that they influence the way that we treat those assets.
Is this not a sort of product of the fact this is very much an emerging field? And because I think people quite use the term crypto asset and digital asset quite exchangeably. And actually one of the things from talking to you guys and reading all your papers that's come out is that really crypto assets are really a sort of subset of digital assets, and digital assets is an incredibly broad set. And as both you and Matt have said, those assets can be such a wide range of things. I mean, you're talking about databases, it's different forms of intellectual property, whereas a crypto type asset is, as Matt has suggested, is sort of something that was aligned to cryptography and private keys. And so, and then even then, when we talk about crypto assets, there are, when we looked at them from a regulatory perspective, there's a huge range of those as well. So it's a sort of effectively a sort of brave new world of an enormous number of new types of assets that reflect things in, I guess, what we might call the real world, but effectively it becomes a real world, a kind of a second real world in itself.
I think that's a really important point, and to that point, I think many people have said, I think many people tried to take the approach that they were going to be technology neutral when they were thinking about these things, and we will explicitly say, or we have explicitly said, I think, that we are not being technology neutral because we have to consider the existing technology, because cryptography, particularly cryptographic authentication, hash functions, and public-private key cryptography and public-private key infrastructure, when you put it all together, allows you to achieve those elements of rivalrousness and excludability that is not able to be achieved within normal kind of other digital assets. So we're not technology neutral in that we have to consider that technology, but what we are is platform, implementation, protocol, crypto token neutral. So we're not going to say buy X, don't buy Y, short Y, or whatever it is, but we need to actually consider that technology exists and recognizes that. Now, that's not to say that new technology that could exhibit the same qualities can't be made in the future, that we would then need to fall within our proposals, and that's also fine. It's just that we think it's really important to kind of recognize the cryptographic element of crypto tokens.
Okay, that's interesting. I think we're moving on to our second question, which I think is connected to this. the 2019 legal statement, which now seems like a very long time ago, as things have moved on so much, explained that crypto assets cannot be physically possessed; they are purely virtual. And I was wondering if that was right. Can a digital asset exist physically, or are we talking about a purely virtual asset? And the reason I ask this is it has quite a sort of knock-on effect in regulation as to whether something is or isn't a crypto asset, and I'll talk about that a little bit later on. And also I was thinking in terms of NFTs, because NFTs is something we're seeing a great deal of now. It's becoming a huge growth area. If you have an NFT of a work of art, you can both have a physical work of art and you can have an NFT of that work of art. So I was wondering, do you think a digital asset can exist both in the real world and digitally, or can it, or if it exists in the real world, is that a real world asset, and is the digital asset a separate thing?
Okay, Matt, shall I start with the first bit and then I'll hand over to you for NFTs, because I know you like that bit. So for the first part about digital existence versus physical existence, I think that's one of the thorniest questions, but I also think it's one of the reasons probably that the common law has struggled to adapt to digital assets in the way that, you know, it hasn't really done in the past with other developments like bank money or intermediated securities. You know, there have been developments that are just sort of, for want of a better word, that have happened organically with those things that don't seem to be happening with digital assets. And I think one of the problems is that there has been too much attention paid to the, is there a physical existence? Is there a tangibility to these assets? When actually, I don't think that that's really the helpful question. I think there can be a reasoned disagreement about whether they have a physical existence or not. So personally, I think they do, because they do simply exist as bits. You know, it might be at a very, very small level that we can't perceive with the unaided senses. But as far as I'm concerned, the fact that they do actually, you know, the fact that hardware, for instance, has a finite storage capacity suggests to me that actually they do have some physical existence. But I think that's not really the legally relevant question, actually, and that it's become the legally relevant question because historically and understandably, all the things we've wanted to possess and all the things we've wanted to treat in that way have just been tangible. And so this wasn't an issue when it was about cattle and bags of gold and watches and laptops and things. But what we are doing now in the Digital Assets Project is to try and decouple the notion of tangibility from possessibility, because I don't actually think they are the same thing. They're not synonymous, and one doesn't necessarily suggest the other. And I think what's really important about assets to be treated in a way which is analogous to conventional tangible assets that we're all used to, which of course might sometimes, maybe even often be what parties want, not always, is that they need to exhibit certain characteristics, and those characteristics are not necessarily the same as tangibility or a physical existence. And the characteristics, I think Matt already mentioned a couple earlier, but basically the things that we have identified as being relevant to possessibility, and then all the legal consequences that flow from that, both in private law and in regulatory terms ultimately, is that those things have an independent existence. And by independent, we mean they exist whether or not anyone lays a claim to them. So they're different to, say, a debt, which of course depends on the claim and on a legal system to recognise it. And that is different from, say, a database, which is there in the world. It has a physical presence in the world, whether anyone lays claim to it or whether a legal system recognises it. So I think that's a really important distinguishing point. So whether or not you think they're tangible, you need to recognise with those things that they are independent of persons and legal systems. Then there's divestibility, that you can pass. So this is to distinguish these things from, say, pure information. Obviously, once I tell you an idea, I can't remove it from my brain. But a digital asset that can be possessed needs to be therefore divestible, so that when I transfer it, I no longer have it. And then amenable to exclusive possession, so that, well, that sort of fits with the divestibility point, that it can be subject to exclusive control. So
going back to that question, so just thinking about this concept as exclusive control, if you've got an asset which is both exists, I'm thinking about in NFTs, and coming on to my next question, which is around NFTs. So say an artist creates an NFT with a real piece of art, and then a real piece of art, and then a sort of secondary piece of art on an NFT which replicates that real piece of art. Are you saying they're both independently possessible?
Yes, I am. Matt, do you want to take on the NFT point? But yes, I think they're both possessible.
Okay, no, it's interesting interpreting what you said there. Yes.
So I think actually the NFT issues are quite interesting, because most of the academic and legal plus market commentary on NFTs seems to be fairly consistent in that most people conceptualize an NFT as a kind of a crypto token. The reason, so it's obviously it's a non-fungible token. So the starting point is that it's a token. It's non-fungible because it's unique and individually numbered, but that doesn't necessarily mean it's non-fungible. That's fungibility is an element of what parties will accept as interchangeable, but people call it non-fungible kind of as a synonym for individually numbered. So we conceptualize them as individually numbered tokens. Normally those tokens will contain an internal data info set, so data or information that has been constituted by virtue of the contract implementation. Some of which will be used for the functionality that we discussed before, and some of which will be used for kind of specifying the token ID and the rarity traits, blah, blah, blah. Sometimes then that info set will also include a link or reference to an external data set, which may be contained on kind of IFPS or somewhere else, or it could even be, I guess like a physical contract, or even like a physical painting or whatever you will. So then you have a crypto token individually numbered, which contains information and which might also be linked to something else. So I think most of the difficulty comes with, if it is linked to something else, how do you characterize that link? And does the token in and of itself convey any additional legal rights external to the system? So does the transfer of the token, or does the token itself give you any copyright in relation to the underlying art? Does it give you a license to use, reproduce, or display the link to the underlying art? And I think in general, the point is that the token is just a token in and of itself, which contains information. The token can be the object of personal property rights. Information itself can't be the object of personal property rights. So the starting point is that when you buy an NFT, you get the token and that's it. Then you have to question whether or not there has been implicit or explicit representations or contracts or anything else that also suggest that additional rights come with that token, such as copyright, such as licenses to use, etc., etc. So I think that's the way that we approach the question.
Matt, there's a couple of questions just come in. Or I don't know if you see them, I'll read them out. So number one, isn't an NFT just a pointer though, not the thing itself?
Yeah, so we conceptualize the NFT as because if you think to the crypto token kind of world generally, like an NFT, ERC20 tokens have been treated as tokens in and of themselves that can kind of attract property rights. Bitcoin, albeit it's kind of constituted of UTXO, has been said that it can attract property rights as, I guess, a token broadly in and of itself. ETH, again, at the protocol level implementation has been conceptualized as a thing that can attract property rights in and of itself. It seems inconsistent to then say, just because you're not using ERC20, you're using ERC721 or 1155, that it's not a thing in and of itself. So we conceptualize the NFT as a thing in and of itself. And then, yes, I agree that it is often used as a pointer to some either internal or external data set, which is effectively information which you can then use to constitute, I guess, an image representation normally.
Okay, I would agree with that. I think an NFT can be a thing in of itself. I mean, we've been working on an NFT project for a client just recently, and it's been very interesting trying to sort of conceptualize who owns what. And there's a lot of intellectual property issues that you have to think about, and you have to be very precise about what remains with the initiator, the artist, or behind an NFT, and what is saleable and transferable as well. And we've talked a bit about possession. We're going to do that in a bit more in a moment. There's another question around: does a digital photograph need to be tokenized before it becomes non-fungible? I don't know if anybody wants to go at that.
I guess if you tokenize it, I think it's a bit of it's a bit of a weird concept, because a digital photograph is, I guess, just information which is not capable of being personal property. An NFT, like we said, is a token that can be used to point to something else, some other form of information. So even when you tokenize a digital photograph, what you're actually doing is you're creating a token, and then you're using the information within that token to point to your information, which constitutes the digital photograph. So that would be the way that we would conceptualize that relationship. And then say you wanted to give copyright or licensing rights in respect to that digital photograph, you could, and you could attach them to the NFT in different ways, probably by a contract somehow. But that would be kind of...
You need to be thinking quite hard about it in advance, rather than just sort of accidentally ending up somewhere.
Yeah, I think you do it backwards. So like the tokenization point is more, you can use tokens as a legal tool to efficiently attach rights to things, or efficiently link a token to legal rights and then efficiently transfer them. That's the way we've been thinking about it.
Okay, very good. I've got a question from Robert Finney. Can NFT create rights to whoever possesses it, like a bearer bond? If so, how, without the equivalent of a deed poll or other formality?
Yeah, I think it can.
Yeah, I would.
Without a deed poll or other formality, I'm guessing you're talking about so if there are, so the starting point is yes, you can. You don't always need to create rights via formalities. You can create rights via contracts, and you can say, you can specify in a contract that the holder of an NFT has the ability to enforce the obligations in that contract, right? So that's easily done. If you need and I think really where formalities come in is generally around transfer. So if you want to transfer, if you purport to transfer some rights via the transfer of a token, that transfer may or may not take effect at law, depending on the formalities that are required to effect that transfer. So I think that's probably really where the kind of the formalities question comes in, is around transfer.
Well, we wanted to actually think a little bit about property right, or I guess possession. I know, Simon, you wanted to just chip in quickly. We were going to ask a little bit about possession, and maybe Sarah, I think you were going to explain a little bit about the difference between shows in action and shows in possession. Simon, do you want to just chip in quickly?
Yeah, well, just to lead into this, the legal statement indicated that digital assets are property, and there have been a number of cases in English courts which have reached the same conclusion. Just caveat that by saying that decisions in courts are specific to the cases, and courts have different ambitions than perhaps HMRC or other entities do. So it's not conclusive, but as I said earlier, that certainly gives an indication about how the law is being used. Can you perhaps give a bit more explanation of the kind of issues that you are considering, when considering whether digital assets could be possessed and transferred, how and whether security can be granted over them, and are you leaning towards a change in the law to expand to a new category of asset, as you've alluded to in your update paper?
Yeah, so the statement that you've mentioned, so from November 2019, which just seems a very long time ago now, we, as Matt said, our work builds on that really, and what our project is aiming to do is to work out the detail really of what was said in the UKJT statement. So there's nothing in that statement, I think it's fair to say, that we actively disagree with, but there are some things that we think now, having done the consultation and the research and the thinking around this, there are things that we do think need to change. So we are going to be, or at least our position at the moment, it's not a completed project, but our position at the moment is that we think there do need to be some changes. And I mean, I think I've probably alluded to this in my earlier answer, as well as in the interim paper. And I think that's about the idea that digital assets, as I said earlier, seem to be presenting and when I say digital assets for the moment, I'm talking about the big wide category with everything that all the types that we've talked about so far this morning. And they do seem to be presenting a particular problem for the development of the common law. And I think that is partly because they have been treated as this big homogenous whole so far, I think, by in a lot of quarters. And then it is pretty impossible actually to say how they should be classified, because of course they're not homogenous in that way, and there are different ways that they can be constructed, there are different ways that they can be used. And I think trying therefore to shoehorn them into the, well, pretty ancient, but until relatively recently still pretty effective dichotomy of things in action, those things that don't have an independent existence of people and the legal system, and things in possession.
Things in action, for the non-lawyers on the call, by things in action, we mean things like debts or something we can't see or put our hands on, effectively.
So things that just they only exist by enforcement, and the obvious example that I do always use is a debt. So that's only there as long as the people who are party to that want to enforce it, and there's a legal system that recognizes it. And of course that's very different to, say, a watch, which is there in the world regardless of any of those claims. But that historically has been the way that the law has approached classifying property. Is it something that exists in the world, like a watch or a laptop, in which case it's been called a thing in possession, and there are certain proprietary consequences that come from that. And if it doesn't fit that category, it has been put in the things in action category, which is, as we've said, those things without an independent existence. And the habit has been to put digital assets, so this is partly in the literature and partly in some of the cases that Simon was referring to. The habit has been really, or the tendency has been, to struggle to see digital assets as this thing in the world. And this goes back to the question earlier about physical existence, digital existence. Because it's hard to see them as having a physical existence, because we can't perceive them with our unaided senses, they have therefore been shoved into things in action. And I don't think, and we don't think at the Law Commission, that that's been very helpful, because they might not look like your conventional things in action, things in possession, but they are very different, I think, to things like debts, because, as I've already said, they have this independent existence. So our view at the moment is that actually maybe the best way, so the law has historically said it's got to be one or the other, it's binary. If it doesn't fit in one, it has to go in the other. And we're thinking now that actually maybe that distinction has outlived its usefulness, and that perhaps, and this talk about digital photos, for instance, and music, those are all unquestionably digital assets, but they're very different to, say, an NFT, because there are things you can do with an NFT that you can't do with a standard digital photograph. So we're thinking now that it may be time to leave that dichotomy behind and actually add another one. We don't know what it's going to be called yet, but this is another sort of box into which we can put property. Sorry?
The third way.
Yeah, the third way, exactly, the tertium quid. So maybe it's time for a tertium quid, and that we have this box where we put things that aren't actually quite like debts, and aren't actually quite like watches. And then we can tailor the legal response to the things that are in that box according to their particular characteristics.
Okay, great. That is interesting. So, and I'm wondering how that will work in terms of one of the sort of big things going on at the moment in the world is DeFi and staking, and it's all very new, trying to get our heads around what's going on there. And I'm wondering if this third category could be sort of relevant to that. And I don't know if either of you got any thoughts on that.
Yeah, I think one of the there's a couple of questions. Maybe I'll just answer them quickly. I think Sarah said tertium quid, which just means, I think it's Latin for third thing. So third way, third thing. So we're thinking of like a third way: things in possession, things in action, and then things, whatever we want to call them, digital things. So that was that question. And then you're right. The other question was, did the UKJC suggest this? I think they probably did, if you read between the lines, that a third category would be useful, but they were obviously bound by describing existing law. So they had to say, if it's useful to put crypto into a category, we have to put them into things in action, because we can't put them into things in possession because they're not physical. So we'll go for the wide category of things in action. But I think they did intimate that a third category would be useful. So we're not kind of just saying much new here, I don't think. But to go to your question, Nigel, I think the really freeing thing about having a third category is that you can use analogies with both things in possession and things in action where useful, but you're not bound by those analogies where they're not useful or they don't quite work. So for things like bailment, so exactly the problem that people are having in the DeFi space is that people can do things with digital assets that they weren't necessarily able to do as easily in the past with physical things, or with rights. So for example, staking is a really good example, and you can stake in many different ways. And there is, I think in the marketplace, there's a debate about how do you characterize a staking relationship, whether it looks more like a
would it be helpful?
It
might be helpful for some of our listeners to explain stake. Do you want to explain staking? Give a 30-second explanation of staking.
Yeah, so I guess broadly, staking is when you kind of encumber you have a digital asset and you kind of encumber it in some way such that it is locked up and no longer liquid. And normally that is for the purposes of then, I guess, in the Ethereum system, the staking is for the change from proof of work to proof of stake, such that you use your staked ETH such that to as a validation mechanism for validating the next blocks. But that's like a kind of a complex kind of underlying mechanism to get to the valid state of the Ethereum virtual network. But broadly, for kind of market participants, staking is encumbering your asset in some way, I guess, such that it can be used for those purposes. And the question is whether that encumbrance or potentially transfer looks more like a loan relationship or looks more like a disposal, or actually whether, if you have a third thing, there might be a way to suggest that it kind of looks a bit like a loan, it kind of looks a bit like a disposal, but actually it might just be a staking relationship. And then the law can just then say, well, a staking relationship should have X treatment overall, because what's really going on here is that control is perhaps divested, but you expect to get your asset back at the end of the staking system. So yeah, I think there's a bit of a debate in the market as to exactly how to characterize it, but I don't necessarily think that just strictly applying loan analogies or disposal analogies is the best way to get there, because you're never going to get a perfect result.
Right. I mean, there's still a lot of different things going on there. Just whilst we're talking about the possession, I think, Simon, you had a question around security, about taking security over digital assets, and I think that'd be quite relevant to this tertiary or third way.
Yeah, indeed. It's such a fascinating topic. I think what I was trying to get at earlier is that the way different people approach it, different bodies approach it, because they have different ambitions. For instance, I feel there's any litigation and compelled to go back to the courts again, but the courts have remedies that they can give to claimants who have been wronged, and some of those remedies are only available if they can characterise as property. And I think some of the issues with digital assets is around security, which can also related to whether or not they're property. You mentioned bailment earlier. Can you have security over a digital asset? What sort of issues have you been considering in relation to that?
This is one of the points that we will work out within that third category. So yeah, it's a really good question, Simon. And I think, the brief answer is yes, I think you can. But you can't necessarily overall digital assets. So I think the way we've done it, the characteristics that I mentioned earlier on is we've decided to do it that way. So do it through principles and do it through those characteristics. So what we are thinking at the moment, as I said, so this is all, we're pre-consultation paper stage. So this is not fixed in stone. And and we're absolutely open to comments on this. But what I'm talking about at the moment is our current position, and the way we think is the best way to approach this, given what I've said about the problems with lumping all these assets together and trying to come up with some, one size fits all answer, which I don't think is effective, is we've decided, rather than categorizing within assets in the sense of saying this category of assets will be treated in this way and this category of assets will be treated in that way, what we're thinking at the moment is that actually we'll do it from first principles. We will set out these characteristics and say, where a given asset exhibits the following characteristics, the following things can then happen. And it may be that if it exhibits certain characteristics, then it can act as security. And my impression is, just thinking about that now, is that that's not going to be, I don't think securitization is going to be a particularly limiting or limited category within that. But I think doing it this way, so saying all these assets might potentially fit in this third category, and where they exhibit the following characteristics, the following legal treatment will then be a consequence of that. I think that's probably the way of treating them that I think is most likely to be able to deal with the subtle differences. But I don't think, I think, to put it the other way, to ask why they would not be able to be used as security, I think gives you a clearer answer. I'm not sure why really, for most of them, you would come up with an answer that would be no. But I don't know, Simon, whether you've got a different view on that.
No, I think I'd agree with that. That there are things with value to someone, and anything with value is capable of being used as security. It's a sort of fundamental point, you think. So no, I think, but it is a thorny issue, particularly given the wide category of assets that fall within this sort of broad definition. Nigel, should we go on to regulation?
Yeah, and we've got a few more questions. There's quite a lot of chat about staking, but around, is it losing control? Is it like a mortgage? Matt has said he's going to consider staking in the paper. So should we wait for that and just move on? We've got 15 minutes left, and we've got sort of we put the two biggest topics first, and the idea was we'd have a few minutes on regulation, a few minutes on smart contracts. So should we talk briefly about regulation? Is a massive topic, but we can talk very briefly about it. Really, this talk is more around the legal definitions and how it might impact regulation. But if any, I don't know if you're. Well, yeah. I was going to say a few words about the current state of play in terms of regulation of crypto assets. So I've been working in this field since 2015, and during 2017-18 there was this huge glut of token issuance, and I got asked to give opinions on whether or not the token somebody was issuing would be a security for the purposes of the FCA. And initially we were sort of rather hunted. It was like, I have a history degree, strangely from Bristol University, where Sarah was based for many years. And especially I had a particular interest in medieval history, where you'd have very scant sources. You'd take these very scant sources and try and work out what on earth might have happened, and all historians would come to a different conclusion. And it was a bit like that with the FCA and crypto for a few years, because the FCA gave very few clues indeed as to how they thought crypto ought to be regulated. There was the occasional statement came out like, treat crypto as you treat any other form of investment product, and other ones saying and then they said, Bitcoin and Ether are not regulated, and if you buy them, tough luck if you lose your money. And that was about it. And then it all changed in 2019. And so I was giving these regulatory opinions, trying to work out what the regulator might be thinking without actually any clues from the regulator. And generally, and then these policy statements came out, there's a consultation paper and then a policy statement came out in 2019, which was very helpful and also very, and actually quite helpful to me, because it said much the same as I've been telling people for the last few years, which was that the FCA they'll look at any unit or token in exactly the same way as they look at any other asset. And so if it has the characteristics of a security, the FCA and any other regulator globally will treat it as a security. So they were dividing assets into things like, is it a security token? Is it an exchange token? An exchange token where Bitcoin or Ether treated much like FX or commodities, and they're generally not regulated, and that's fine. And then you'd have the security tokens with the attributes of security, like a debt instrument or an equity, which will give you, I suppose, ownership rights, and those are a security. And the crypto is purely, really just a delivery mechanism. And then you have this category in the middle, which would give you sort of rights of one sort or another. Utility tokens, they were known as, and those are the sort of cloudy area in the middle. And then you have, and I've done a lot of work around payments as well, and there was this rather sort of cloudy area as to whether certain tokens carry payment rights or they might be e-money. And ultimately, the answers are you treat them exactly as you would any other form of investment, and it's just another way of delivering things. And then things will change again in 2020, 2021 with the introduction of the AML, or the expansion of the AML regime to include Bitcoin and Ether, largely because the regulators realized that there was a huge amount of money laundering going on, and this was a very, very convenient way of fencing difficult assets and paying for difficult assets and paying things you didn't want the regulators or the tax authorities to know about. And that's where I think we start to hit the sort of legal definitions that Professor Sarah and Matt have been talking about, because in the expansion of the AML regime, there were only two categories, one which referred to crypto assets. And there was not a definition of there was a definition of what a crypto asset was, which was an asset existing on a blockchain, a digital asset existing on a blockchain, etc. But that's an area which I think is open for a lot more interpretation. The other thing there were two forms of crypto asset activity which qualified for AML. One was operating a crypto wallet, and the other was operating a crypto asset exchange. And that's where the more we can, I mean, I've learned so much just from talking to Sarah and Matt about this subject. I feel I have a much better understanding of what is a crypto asset and whether something's a crypto asset. And one of the big areas where I've been thinking about quite a lot is if you've got if you've got an asset which exists in the real world but is then recorded on a blockchain, is that a crypto asset, or is that just purely a method of recording something? And that's really where law hits regulation. And then we've got this expansion of the financial promotions regime, which Simon mentioned earlier on. I am on a Crypto UK task force thinking about this and thinking about the consultation paper. Again, this appears to me to be a sort of stealthy, it's a very efficient way for the FCA to regulate the space without actually regulating the space. And by that, I mean, they're not interested in regulating Bitcoin, crypto, but they're regulating people who are engaged in that space. So if I send a Bitcoin to Simon, I'm not engaging in any financial activity, but if I operate an exchange or I'm selling something or promoting something, then I'm caught. And it's quite a clever way to approach it.
Do you think that's sort of regulation by the back door?
Yes, it is, I think. I could call it efficient, I could call it lazy on the part of the regulators, but I'll call it efficient because I think they do not want to get bogged down into the nuances around crypto assets. That's really one for the lawyers rather than the regulators, and really one more with discussions around shows and actions, so shows in possession or shows in something else, which Matt and Sarah have so articulately described.
And Nigel, I wondered whether the third thing approach, and I guess that one of the themes of our paper will hopefully be that this third thing kind of frees up the legal analysis to apply analogies where helpful, but also recognize that crypto, and particularly DeFi, is different and does operate in an idiosyncratic way. Do you think that that acknowledgement in and of itself and laying those kind of foundational kind of thoughts from a legal perspective and a principles up perspective, do you think that would help regulation to become more nuanced and recognize the differences and idiosyncrasies of crypto?
Yeah, actually I do. I think that would be extremely helpful. And I think the reason for that is and as a sort of lawyer who spends quite a lot of time advising people on regulation, you're only as good as the definitions you've got when you're interpreting something. So if you're interpreting something as a crypto asset, whether or is something a crypto asset, we kind of get to a hard stop as things are. But with this new category and these sort of thoughts around staking as well, and being able to have this sort of third category, it allows us to be much more nuanced. and more interpretive. And I think one of the pluses in this country is we have principles-based regulation, unlike certain other regimes where the regulator expects us to be interpretive, doesn't necessarily set very hard guidelines. And what that means is it allows the regulation to move with, I guess, the times, and move with the markets, and move with the legal definitions as well. So I think it will allow us to sort of take the regulation and gives it a bit of flex, if you like.
Yeah, I think that will be one of the key features, that if you try, one of the problems with the crypto markets is that they move very quickly, and there are thousands and thousands of different products that are being kind of tested in real time by the market. And if you try and take a results-oriented approach, you can get a result in that specific area, but then you'll just push something elsewhere. Like in the ICO era, ICOs have effectively been stopped, but that has just moved kind of to do the same thing, but via VC funding, which is then blocked retail out of what would have otherwise been a very kind of like potentially volatile but potentially lucrative kind of opportunity to participate in the new market. I think
one of the philosophies behind the whole crypto project, going right back to the original Bitcoin paper, is sort of democratization. And you're right, in a way, if it's over-regulated, and I noticed there's quite a few questions on the Q&A, which a lot of which are around the FCA. Is the FCA regulating without regulating? What is the concept of tokenization and collective investment scheme? I can talk about another issue altogether, the UK's approach. Yes, I mean, there is a danger, as you say, Matt, that if we over-regulate, we actually defeat the object. The object, it's a question, do you protect people from themselves, or do you give people the opportunity? And that's really what it comes down to. The original Bitcoin project was all about democratization, all about giving equal opportunities to anybody around the world. And one of the beauties of the sort of Coinbase or Bitcoin type markets is they're 24/7, 365 days a year, and anybody can participate. And if you look at the participation rates in certain countries, I mean, the UK is not the leader in this at all. I mean, there are countries like Malaysia and Nigeria, and India, where you have an incredibly high participation rate in crypto markets, because quite honestly, all you need to participate is one of these. So, the question is, is the danger for regulators, are you protecting people themselves, giving the VC funds the best opportunities by doing so, and therefore closing those markets, closing those opportunities to make money to the ordinary investor? And that's a very important philosophical question. I'm not sure I know the answer to it, but I think it's a very important question. Yes. So I mean, we've got a long way to go. The stuff around financial promotions is will be very prescriptive, and I think we don't know quite where we're going to get to yet with it. It's still very much a consultation process. There's an awful idea. This is still terribly dangerous. We can't possibly let these ordinary people sort of risk their all their possessions by investing in this toxic stuff. But the reality is, a lot of ordinary people made a great deal of money from doing this. So I don't know. It's a really good question, to which there is no absolute answer. I think we have about just a few minutes left, and Simon wanted to ask a quick question about smart contracts, which I know is another area you know a great deal about. So if we just finish off today with that, and if we can take any Q&A at the end, if anybody else wants to ask anything, we can, if anybody's got time.
Yes, thanks, Nigel. Sarah, Matt, we just wanted to touch on smart legal contracts. Just briefly, you just finished your, we just reported on your consultation on that. Perhaps you could just sort of perhaps give us a summary of sort of conclusions. I mean, I think it's right to say that your overall conclusion was that we didn't need any law changes currently, but perhaps you could just give us a bit more colour on that.
Yeah, of course. So when we started that project on smart legal contracts, our view was that we would probably need to make some substantive legal changes, and part of our consultation was about finding out from people who were already using those contracts and their legal advisors, and technology platforms. I mean, we spoke to the broadest range that we could. And it became apparent actually about halfway through probably that that wasn't going to be the case. And you know, as the Law Commission, we don't view that as any sort of disadvantage to the projects. You know, if we don't end up making law reform, then that's fine. We just like to check whether we need to or not. But we did need to do something, and that's what we did in our advice to government that we published in November last year. And that was really just to, well, to make the point that the contract law of England and Wales is already perfectly well suited to accommodate smart contracts, without any substantive changes really needing to be made. But we also, in that advice, made it very clear what the application of the current devices looks like, because I think that was the answer that we got to, which was we already have the right tools and their application is going to be a bit different, but in legal terms they're absolutely fine as they are. So if I just give you a couple of examples very quickly. First, I think it's probably worth mentioning interpretation, which is, as we all know, interpretation of contracts is a fantastically difficult area anyway, even when we're talking about agreements that are between two human beings. Once you involve a machine in that, so a smart contract is obviously coded, it's an automated agreement that addresses, at least to some extent, a machine and tells a machine what to do, then there's an extra layer of difficulty in there, because there's only one way, say, that a machine will interpret language, whereas when we're asking about contracts between humans, we say what would a reasonable observer make of that agreement. So what we did there is to say, well, actually, the tools of interpretation that we already have work broadly well. We just probably need to tweak them slightly, in that maybe the best question is not what a reasonable person would make of that without more, and certainly not what would a reasonable machine make of the written agreement in code, because of course there's no such thing, but to say what would a reasonable coder, right? So somebody who has knowledge of human language and knowledge of how machines will respond, and then you can bridge the gap in that way. And that's not a million miles away, of course, from what we do in standard contract law anyway, where we imbue that reasonable observer with knowledge of the context and circumstance. I'm aware of the time. I was going to give you a couple of examples. I'll probably just stick with that one unless you have any further questions.
Oh, that's great. No, thank you very much. We're right on time as it happens. So I don't know if anybody wants any to sum up. First of all, to say thank you very much to our fantastic panel today, and to Matt and Sarah for taking the time to talk to us and sharing their insights, which I thought were really interesting, and actually certainly shape our thoughts going forward in terms of how we interpret crypto, how the law will see it, how we as sort of financial regulatory lawyers might interpret things further and actually have a much greater depth and nuance to it. So first I want to say thank you to everybody for turning up, and thank you to all our participants and all our attendees. So I think without any further ado, I think that's probably it for now. But if anybody has any questions they'd like to send to us, please contact me or Simon. And if anybody's got any questions which they would like us to share further with Matt and Sarah, we're very happy to forward those along. So other than that, so thank you very much indeed to everybody for coming along and for making this such an interesting event.